Today we will be going over the updated Secure 2.0 hardship withdrawal rules. We will be reviewing the Secure 2.0 Act, how hardships worked before this was enacted, what has changed with this, what this means for you as a plan sponsor, and the action steps that we're going to take. Let's start with a brief overview of the legislation behind these changes. In December of 2022, the federal government passed what is commonly referred to as Secure 2.0. This is a sweeping federal law designed to expand access to workplace retirement plans, help Americans save more money, and simplify retirement account rules. It builds upon the original Secure Act from 2019, which stands for Setting Every Community Up for Retirement Enhancement. Secure 2.0 continues and expands on those earlier efforts to modernize retirement plans and increase participation. The updates introduced in this law touch several key areas. First, they impact how retirement plans are administered, including new requirements and options for employers. And secondly, they improve employee access to retirement funds in certain situations, helping provide more flexibility to them. And finally, they aim to simplify the process overall, making it easier for both employers and employees to navigate and use retirement plans effectively. And the next slides will walk through how this impacted hardship withdrawals. One important change focuses on giving employees limited access to their retirement funds in times of genuine financial hardship. Hardship withdrawals allow employees to have access to a portion of their retirement savings early, but only under a very specific circumstance. To qualify, the withdrawal must be for what's defined as an immediate and heavy financial need. This means that these funds are intended strictly for urgent and essential expenses, not discretionary spending. The intent of this provision is to provide financial relief during serious life events while still encouraging employees to preserve as much of their retirement savings as possible. Before Secure 2.0, the process for hardship withdrawals was more complex and documentation heavy. Employees were required to demonstrate that they had a legitimate financial hardship in order to access their retirement funds early. This meant providing that they had met the immediate and heavy standard, and from the employer's perspective, this involved collecting supporting documentation, things like a medical bill, eviction notice, or other financial statements to verify their request. Plan sponsors were then responsible for reviewing that documentation and retaining it on file, which added administrative burden and increased compliance responsibilities. Now let's look at one of the key changes introduced under Secure 2.0. A major update is the allowance of self-certification for hardship withdrawals. This means that participants can now certify on their own that they meet the requirements for a hardship, specifically that they have an immediate and heavy financial need. As a result, employers are no longer required to collect or review supporting documentation such as bills or notices, which significantly reduce the administrative burden we talked about on the previous slide. However, it's important to note that this is optional. This provision only applies if the plan document allows for self-certification and you as the plan sponsor have chosen to implement it. So what does self-certification actually mean in practice? Under this approach, the responsibility shifts more to the employee. The employee simply confirms that they have a qualifying hardship and the amount that they're requesting is necessary to meet that need. From there, you as the employer may rely on your employee statement, provided you do not have any knowledge or reason to believe that the statement is being misused or abused. There's no longer a requirement to collect or review supporting documentation like bills or formal notices. This makes the process much simpler and faster, while still putting the responsibility on the employee to ensure that the request is accurate and appropriate. This change simplifies plan administration and reduces the burden on employers by eliminating the documentation requirements. At the same time, it allows employees to access funds more quickly when they need them most, and it aligns with current IRS guidance, keeping plans up to date and compliant. Even with self-certification, there are still a few important considerations. Plan sponsors need to ensure that their plan allows for it and follow consistent procedures across all participants. Even though specific documentation like bills are no longer required, record keeping on these is still important, and plans need to track the amount withdrawn and maintain the employee certification, as this is something an auditor would expect to see from the plan. Now, it's also important to highlight what has not changed. First, the tax implications remain the same. Hardship withdrawals are still taxable, and depending on the participant's age, they may also be subject to early withdrawal penalties. Additionally, the core hardship rules still apply, and there are still limits on how much can be withdrawn, and the withdrawal must be for eligible reasons, which we will discuss on the next slide. There are 7 IRS-defined situations that qualify for a pre-approved hardship withdrawal. They include things like medical expenses that are not covered by insurance, purchasing a primary residence, not a secondary home, and tuition or education-related fees for an upcoming term. They also cover funeral or burial costs for a beneficiary or immediate family member, preventing foreclosure or eviction, and repairs for casualty damage to a primary residence that are not covered by insurance. Finally, hardship withdrawals are also allowed for federally declared disasters, as long as the event is officially listed by FEMA. So while the process has become easier with self-certification, the qualifying reasons themselves remain the same. Finally, let's look at what this means in terms of action steps for plan sponsors. First, RPC will work with you to update plan documents, if needed, to allow the self-certification. It's also important to coordinate with your record keeper or third-party administrator to ensure that processes are aligned and implemented correctly if you work with additional service providers. And of course, communicating these changes to the employees is key, so they understand their options and how the updated process works. At RPC, we're here to support you in every step of the way, providing personalized retirement solutions for all. And as always, please reach out to your dedicated consultant with any questions. Thank you.